Jamie, we sort of know some of the reasons why a bond is denied, right? You basically look at the criminal history, a danger to the community. But does the fact that he's a former lawyer, because he's now a former lawyer, he was disbarred, does that play a role at all in the judge's mind? The fact that this was a lawyer with a duty to his clients and just some of the things he's done has been pretty well publicized.
I think it does, Michael. I think that the judge is looking at, at least the allegations on their face and appears to be making a calculation to protect Mr. Murdaugh from himself. Historically, in pretty much every single state, that is not the role of bond. Pretrial release is, for the most part, a right within reason, unless a reason could be shown why they shouldn't be released. And presuming that this man was a lawyer and didn't have any sort of violent criminal history, the idea that he was absolutely denied a bond, I think, is probably outside the scope of what most courts would entertain. With that said, I think this judge did a great job at setting some guardrails and allowing the defense attorneys to come back into court and present some evidence that he, in fact, is not a harm to himself or to others. But at the end of the day, I think that, when we see a political climate, in our country and really, in all of our communities where, people are being denied bond for reasons that they can't afford, the money, this kind of flies in the face of that. And I think the judge will likely reconsider this when he gets some reassurances that the defendant is not going to harm himself or others for that matter.
Absolutely. I agree with you. I think that's why he wanted to order there the psychological evaluation, because this guy, again, there were a lot of acts. He was under opioid addiction, as we heard. There were a lot of things that he was accused of doing and even admitted to doing that were just not safe for the community. I want to call up a quick full screen here on the bond decision factors really quickly. You have the judge considers a significant flight risk. I would say check, as you heard the attorney arguing. He's got a lot of money in his family. Serious risk of committing other crimes. He has shown that while he's out, he's had some trouble. Danger to the community. Absolutely. I think that's true. And so all those things, when taken into account, I think his decision was well considered. And also, I want to play here a quick soundbite from the attorneys for the sons of the housekeeper. These were the folks that the money was directed to. These are their attorneys talking about this particular crime. Let's take a listen.
We spend a lot of time in our practice litigating cases against lawyers that steal from their clients or breach their duties. And, a lot of times we say when a lawyer steals with a pen, it's just as bad as somebody who steals with a gun. We talked about that in the court there today, and a lot of times it doesn't resonate. But I actually believe that it did resonate today, that in South Carolina, if you're going to do this with a pen, it's no different than somebody doing it with a gun. It places people's lives at risk and really harms society.
Jamie, fair statement?
Yeah, there's no question about it. I don't think there's any more egregious act than an attorney taking advantage of their fiduciary responsibility of a client, especially when the client was his housekeeper, who, my understanding is, helped care for his children and helped care for him. This case just reeks of just in your face, why lawyers sometimes have a bad name. I don't know if it should factor into bond decisions necessarily, but there's no question that the prosecutors and the court are absolutely entitled to feel some kind of way about these allegations. This is as bad as it gets from a lawyer's point of view.
Yeah, and I want to reiterate what you said earlier and follow up on the fact that generally, in my experience, and I want to know about yours, when someone doesn't have a criminal background, generally, even though he's had some open cases that are being investigated, generally, bond is not even an issue. You're allowed to go. So there was some other things here involved in this judge's decision.
Yeah, no question. And not only was, there's no bond. So, it's not as if he can put up $250,000 or $100,000 or $50,000 to be released. There is no bond, which is very, very extraordinary. And again, I won't be surprised if the attorneys are back in court in 3 weeks with what the court requested, making a presentation that he should, in fact, be released under some conditions, whether that's drug testing, rehab, psychological ongoing evaluations, whatever it is. But the idea that he has to sit in jail for a nonviolent offense, even though it's so egregious, is really outside the scope of what I've seen in my practice.